Hi, I apologize for the delay in the video lectures. I had bronchitis for a couple weeks and I did not really have a speaking voice at all. With that being said, I wanted to get on here today and run a video lecture with you on the third module, which deals with the Fifth Amendment. So this is a significantly shorter module than the Fourth Amendment one we did, just because there's so many exceptions to the Fifth Amendment, or to the Fourth Amendment. So the Fifth Amendment, what we as future criminal justice professionals really care about are due process of law and kind of self-incrimination. So the Fifth Amendment in general protects your right not to be indicted before a grand jury in federal court only, your right to not be tried for the same crime twice, which is double jeopardy. There's a really significant exception to double jeopardy, though, that is you can be prosecuted by both the state and the federal government. That does not count since they are separate sovereigns. There's this takings clause that if your property is taken, you will receive just compensation. You have your right to due process. This generally is this concept of that we treat everyone the same. Everyone, if we're going to have arraignments, everyone has an arraignment. If we are going to do bail, everyone who's similarly situated is treated the same. And then for us, this privilege against self-incrimination is really where we're going to focus our time. So if we shift down to the privilege against self-incrimination, it is based on the Fifth Amendment clause that says no person shall be compelled in any criminal case to be a witness against themselves. Under this, there is this idea of, can we infer guilt? Can we say, well, if they were truly innocent, they would take the stand and defend themselves? And the answer to that is no, we cannot do that. The Fifth Amendment means that we cannot comment on a defendant's failure to testify. Can coerced confessions be used against a defendant? Generally, we do not want to do that. They're not as reliable. And then what we're really going to talk about today in this one is what is custodial interrogation. Okay. So very important concept to the Fifth Amendment analysis is that the Miranda warnings only need to be read if you are in custody and being interrogated by police, a custodial interrogation. There is not a requirement to read Miranda rights upon every arrest, only if you are in custody plus interrogation. The Miranda warnings come from the Miranda v. Arizona case in 1966. Miranda was arrested and questioned. After a couple hours of interrogation, he wrote a confession, and his attorney objected that he had never been advised of his rights. He didn't know that he had the right to remain silent. He didn't know he had the right to an attorney at that point. And so the court agreed. Officers need to issue Miranda warnings, the general ones that we see in here on TV, when a suspect experiences a custodial interrogation. Each piece needs to exist. Custody, in general, we think of actually being arrested and held and detained at a police station, but it can be in different circumstances. What we really want to ask is, would a reasonable person feel that they could not leave? And if that is affirmative, that is a yes, then the suspect is in custody. Interrogation is questioning or the functional equivalent of questioning. Okay? So in a couple cases to kind of further distinguish these concepts. In Oregon v. Mathiasen, Carl Mathiasen voluntarily came to the police station and spoke to the officer. He confessed, but he wasn't arrested. He was arrested later. They used that confession. The Supreme Court said that's not custody. He chose to come to the police station. It was voluntary. Okay. The next case in the course pack is the JDB case. This solidifies that juveniles have the same Miranda rights, and not only do they have the same Miranda rights, they need to be certain that the Miranda rights are given in a way that a child can understand them. Okay, so the functional equivalent of interrogation deals with this idea that an officer does not expressly question, which is kind of what we think of when we think of an interrogation or an interview, as they're more commonly called these days. We think of someone being in a small room with a police officer, a recording device, and them asking questions, and eventually the person cracking or choosing to waive their rights, or they remain silent and they ask for their attorney and they preserve that right. A functional equivalent of interrogation is an officer, by their words or conduct, engage in conduct that they know or should have known is likely to elicit an incriminating response. So the police know that the behavior is likely to elicit an incriminating response. If that exists, then the Fifth Amendment would surface to protect that in confession, because the rights were not read. And so the case where these ideas came from, in this first case, Innes, the police determined that a functional equivalent of interrogation did not occur. 2 officers were escorting Innes to the police station. Or, I'm sorry, 3 officers. They were discussing that the gun involved in the robbery hadn't been found, and that there was a school for handicapped children located nearby, and just that they needed to locate this weapon before a child hurt themselves. Innes then interrupted and told the officers to turn around the car so he could take them to the gun. So this was just a casual conversation. The officers didn't expect, or were not trying to get Innes to respond this way. So the confession's admissible. Okay. If you have any questions about it, or it still doesn't make sense, let me know. Okay. So after that, it is an affirmative duty on the defendant to explicitly invoke Miranda rights. If you want to use and preserve your rights, you need to be unambiguous and clear. You need to say, I'm not talking to you because I'm invoking my right to an attorney, and I'm going to remain silent. I'm not talking to you. But if you just are silent, that is not sufficient. So in this case, Tompkins was silent for a few hours of interrogation. He committed a crime in Michigan. He was arrested in Ohio. His attorney was driving from Michigan to Ohio to be there with him, and so he was quiet. At the end, the law enforcement officer said, I have to ask, are you praying for forgiveness for the murder you committed? And Tompkins said, yes, I am. That's a confession. And so because he had not explicitly invoked his Miranda rights, it was not explicit that he waived his rights when he acknowledged that he was seeking God's forgiveness for this crime. So the burden is on the defendant to clearly and explicitly invoke Miranda. Okay. The last big concept about the exclusionary rule and how it applies to confessions under the Fifth Amendment is that, just the same as the Fourth Amendment, if constitutional rights are violated, the evidence cannot be used against the defendant in a court of law. So the remedy is we exclude. This comes from a case called New York v. Quarles. Quarles was suspected of an armed robbery. An officer saw him leave a grocery store, stopped him and frisked him, noticed that he had an empty gun holster, and said, "Where's the gun?" And he had hidden it in the grocery store on a shelf. which is a huge danger to anyone who is in the grocery store. So officers, Quarles challenged his confession because he had not been read his rights before he was asked questions by police when he was detained. And the courts responded that there is an exception to the exclusionary rule for public safety. Public safety was at risk here, and it was reasonable for the officer to secure the weapon at this time. And the information gathered just for that purpose is admissible under the Fifth Amendment. Okay, and I think that makes a lot of sense. We want our law enforcement to be able to keep us safe and keep public safe, to reduce harm. So this exception really allows officers to keep everyone safe. Okay, last point to make about the Fifth Amendment today is that it only applies to communication. It does not include your blood samples or DNA. So in the Schmerber case from 1966, Schmerber was arrested for drunk driving. He was injured. Officers took him to the hospital, and while he was there, the officer told the hospital staff to take a blood sample for toxicology report, which came back that the defendant was drunk. And the defendant challenged that because he had refused the breathalyzer and he did not consent to the blood test. And he said his Fifth Amendment protection against self-incrimination should keep this out. And the court responded that no, the Fifth Amendment protects words and writings and some gestures, but not your blood or your DNA. And so this exception is kind of what permits certain, most jurisdictions actually to swab for DNA upon arrest under the Maryland v. King case in 2013. But it goes all the way back to 1966 when the courts ruled that blood was excluded from the Fifth Amendment protections. So I hope that this helps clarify some of these Fifth Amendment issues. If you have any questions, definitely feel free to reach out via email.